Order in the court. We'll hear argument next in case students for fair admissions versus the president and fellows of Harvard College. Mr. Norris?
Mr. Chief Justice, and may it please the court. Grutter assumed that universities could use race in a narrowly tailored way if they just did it like Harvard. But this court never had any evidence against Harvard. But now you do. And that evidence proves that none of Grutter's core assumptions were ever true. First, Grutter assumed that race would only be a plus. But race is a minus for many Asians, a group that continues to face immense racial discrimination in this country. Harvard ranks Asians less likable, confident, and kind, even though the alumni who actually meet them disagree. What Harvard is doing to Asians is shameful, but it's a predictable result of letting universities use race in highly subjective processes. Second, Grutter assumed that applicants would be treated as individuals, not as members of racial groups, but Harvard gives racial preferences based on the box that applicants check, even if they never write about race or explain how it influences their views. Grutter assumed that universities would seriously consider race-neutral alternatives, but Harvard never once did, so until 2017, 3 years after we sued it. That's how Harvard uses race. And Harvard is supposed to be the model. This court should admit that it was wrong about Harvard, wrong about Grutter, and wrong about letting the poison of racial classification seep back into education.
Hey, Mom, can I have breakfast?
Sure, sweetie.
Good morning, fourth period. Breaking news. The Supreme Court just held a hearing for students for fair admissions versus the president and fellows of Harvard College. Live at the scene, we have reporter Adrian Hayes to give us some more information. Take it away, Adrian.
Here outside the Supreme Court, the Students for Fair Admissions organization just accused Harvard College of the unlawful use of race in admissions.
This is a very controversial case that has been repeatedly debated throughout history. Can you tell us a little bit about the other cases that were related to this one?
The organization's main reference was the infamous Grutter v. Bollinger's case, where the Supreme Court discussed whether Michigan Law School's use of race in student admissions is in violation of the 14th Amendment's Equal Protection Clause or the Civil Rights Act of 1964. The court ruled that affirmative action is not in a violation of existing laws as long as races are evaluated individually.
But things aren't so cut and dry, are they? What types of limitations are in place regarding affirmative action?
You're right. In the case of Fisher v. University of Texas, the Supreme Court also ruled that race-based admission processes must hold up under strict judicial scrutiny and the result must serve a compelling government interest. The Harvard plan, ruled lawful in Regents of University of California versus Bach, is used as a benchmark for race-based admissions. Harvard College's admissions were said to use race as only a factor used to effectively evaluate applicants in the context of their background instead of only looking at race.
Why is the Harvard plan relevant to the Grutter case?
The Students for Fair Admissions' main argument is that Grutter ruling was unlawful in regards to the Civil Rights Act of 1964, and that Harvard, originally the model for the correct type of affirmative action, has been using race in isolation to decide students' admissions. This will be the first time since the Grutter case where affirmative action as a whole will be officially re-evaluated in the context of the Civil Rights Act of 1964.
Thank you so much for your time, Adrian.
Want a break from the...
Hey, guys.
Hey, Adam.
What are you guys working on?
College applications. Hey, what is your opinion on affirmative action?
I guess affirmative action takes race into account, so it makes the process more fair, right?
But doesn't that just make it less merit-based? I feel like how some groups get an advantage over others just because they're a different race kind of makes it a little unfair, don't you think?
No, I disagree. I think affirmative action just makes the process more equitable because certain minorities are at disproportionately affected by factors like, for example, poverty. And they have to work harder for them to get on equal footing with other races. I think affirmative action just makes it so that colleges have to take this into consideration in their admissions.
But why don't they just, consider these factors separately? Why not make it income-based rather than race-based?
Statistically, that's very similar to race-based admissions.
Fine then.
Did anyone do the reading I signed last night? Okay, well, then can anyone tell me about the Civil Rights Act of 1964? How about you, Adam?
Right, the Civil Rights Act, it, gave people civil rights.
Well, what does that mean?
I'm not
I
sure.
know. The Civil Rights Act of 1964 prohibited discrimination on the basis of things like gender, sex, religion, and race. It also prohibited the use of segregation in public areas and was administered during the presidency of Lyndon B. Johnson.
That's wonderful, though I'm looking for an answer from Adam. So Adam, why don't you tell me what formed America's very basis of its a commitment to equality?
I know. It's
The 14th Amendment, it granted the privileges and immunities of citizenship, due process, and most importantly, equal protection. Everyone has inalienable, untakeable rights, just because they're human. Life, liberty, and property. Though at the time, it only kind of applied to white landowning males.
That's wonderful. Okay, so now let's go over what you'll be working on in class today and your homework due tomorrow.
You wanted an overview of racial discrimination? So here it is. For more help, check out my political history ultimate review packet. The link is in the description box below. Get those brain cows ready for milking because we ain't got no time to waste. In the early 1950s, there were many cases arising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., all relating to the segregation of public schools on the basis of race. In each of these cases, African American students had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. The case that came to be known as Brown versus Board of Education was actually the name given to these 5 separate cases. These students argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs, or the team of lawyers that were suing, were denied relief in the lower courts based on Plessy versus Ferguson, a previous Supreme Court case that held that racially segregated public facilities were legal, so long as the facilities for blacks and whites were equal. This was known as a separate plus equal doctrine. After the 3-judge panel in the United States District Court ruled in favor of the school board, the plaintiffs then appealed to the United States Supreme Court. Brown versus Board of Education resulted in the Supreme Court holding that separate but equal facilities are inherently unequal and violate the protections clause of the Equal Protections Clause of the 14th Amendment. They reasoned that the segregation of public education based on race instilled a sense of inferiority that had a hugely detrimental effect on the education and personal growth of African American children. Soon after, more laws supporting equal rights between different races were implemented. The Voting Rights Act of 1965 prohibited all states, specifically those in the South, from the use of discriminatory practices, preventing some races from voting. The extent of this act reaches beyond simply allowing people of all races to vote, but it further prevents states from including literacy tests and other prerequisites that some races are significantly more likely to qualify for than others. In a separate case, Loving versus Virginia, a court case was issued after an interracial couple, Mildred Jeter and Richard Loving, were charged and arrested for violating a Virginia statute that forbade interracial marriage. Loving versus Virginia was a court case in which the court argued whether Virginia's anti-miscegenation law, which banned interracial marriage, violated the 14th Amendment's Equal Protection Clause. The court unanimously ruled that yes, this law was in violation of the Equal Protection Clause. Their reasoning was that the states cannot infringe on the right of one race to marry another, and was that Virginia's anti-miscegenation law did not serve a rational purpose as the Equal Protection Clause.
With Justice Clarence Thomas's concurring opinion saying that we should reconsider cases such as Obergefell v. Hodges, the Supreme Court case which forced states to recognize same-sex marriages, people are worried. Obergefell was the case that would set the precedent that the 14th Amendment's Due Process Clause guarantees the right to marry, as it is included in the right to individual autonomy, safeguarding children and families by allowing home building, protecting the most intimate association between two people, and being recognized as the keystone to social order. Because of this, it guarantees the same right for same-sex marriage. Some will be joyous at its overturning. Dissenters stated that the Obergefell was a case where the Supreme Court overstepped as an unelected body and exercised legislative power which it shouldn't have had. This is a part of the overall fight to increase state powers, letting state legislators define their own laws instead of the federal government.
Hey everyone! Today we'll be going over the Equal Rights Amendment of 1972, the amendment that was arguably the closest to being implemented, yet ultimately failed. First, we have to look at second wave feminism, the movement where 1960s women fought for their rights in all parts of their life rather than just suffrage. It is best known for the attempt to pass the Equal Rights Amendment, legislation that had both strong proponents and opponents.
Equal rights.
This is Alexander Hart at the scene where a couple of protesters are riled up at Capitol Hill. We are about to interview some of them now.
Equal rights. We deserve.
This is women's rights activist Alice Paul, the one who proposed the Equal Rights Amendment. She has been fighting with the National Organization for Women through everything: the silent vigils, hunger strikes, and imprisonment.
For what are you protesting?
For the Equal Rights Amendment, with the recent decision of Reed v. Reed, discrimination on the basis of sex has been declared unconstitutional due to the Equal Protections Clause. We are one step closer to codifying true equality for women.
Can you tell me, what does the Equal Rights Amendment entail?
Passing the ERA means that there's no legal discrimination in the matters of divorce, employment, property differences, and other matters that should not have existed in the first place.
Thank you for your time.
Equal rights. Equal rights. We deserve equal rights. Equal.
Next, we'll be talking to the protesters against...
This is lawyer Phyllis Schlafly, head of the Stop ERA organization. She is well known for both censoring herself as a model housewife and being heavily politically involved. Schlafly reshaped American conservatism and is referred to as the first lady of the conservative movement.
I'll think on it. Thank you. Ma'am, can you tell me why you're against...
Well, first, I would like to thank my husband Fred for letting me come here. Oh, I know that just irritates those women's livers. Well, we're here to protect America's fundamental core values. Those pro-ERAers are looking to upend civilization as we know it. They're planning to destroy America's strong system of male breadwinners, send our daughters to the army, and allow women to kill their infants.
As a woman yourself, what do you think about the arguments that say the ERA is for all of women's rights?
Well, that's just a moot point. First of all, letting an amendment pass would just upend the work we've already done in the first feminist wave. But not only that, but we don't even have sexist laws now. The only one I really know is one where women can't make wine without their husband's permission. Other than that, we're just fine.
Thank you for your time, ma'am, and thank you for the pie.
Stop ERA! Stop ERA! Stop.
Ultimately, Phyllis Schlafly and her supporters won. While the Equal Rights Amendment was passed by Congress in 1972, it failed the 3/4 state ratification due to anti-ERA pushback. However, many state governments independently implemented the ERA in their own constitutions. Thank you for listening.
Protections against discriminations towards those with disabilities is broad on both the federal and state level, and have appeared in numerous Supreme Court cases, two of which are Barnes v. Gorman and Chevron USA Incorporated versus Casable, where discriminations were brought to the court. The ADA, or the Americans with Disabilities Act, outlines the protections we give to those with discriminations, especially in areas of employment, education, and transportation. Thank you for listening.
Alright, that was nice. Next up we have Adam.
Hello everyone, my name is Adam Mallard, and my presentation is on affirmative action. So what is affirmative action? Affirmative action is a set of institutional policies aimed to promote inclusivity in certain organizations. One common misconception is that affirmative action requires the use of certain quotas. For example, one might believe an organization or a university that uses affirmative action requires at least a certain percentage of the incoming freshman class to be of a certain race. However, this practice has been deemed unconstitutional by a case we'll get into later on. Affirmative action simply enables some institutions to consider aspects like race as a simple factor of decision. Even the other day, two of my friends were arguing over whether affirmative action is good or bad. My friend who said it was good, advocates of affirmative action, they say it promotes diversity and inclusivity of those who are less represented. However, my friend who was against it said that it undermines meritocracy and that people get in for factors other than their actual merit. And some people say that colleges can use income rather than race to make these decisions, considering in the context of their background. Now, we'll get into some common court cases. The first one we're going over is the Regents of the University of California v. Bach. In this case, Alan Bach went against the UC Davis Medical School after he applied twice and was rejected both times. He realized that his qualifications actually exceeded those of other minority students who were accepted. And the court decision ruled that the use of racial quotas at UC Davis Medical School was a violation of the Equal Rights Clause of the 14th Amendment. However, in another case, Gordon v. Bullinger, race was used as a factor of admission in the University of Michigan's law school. However, it was deemed constitutional because it was evaluated in the context of the entire applicant's background and was put against other factors, and it was not a sole decision factor. In another court case, the Parents Involved in Community Schools versus the Seattle School District, the use of race in admissions was deemed unconstitutional because of racial quotas involved. Finally, in the Fisher v. University of Texas case, the use of race in admissions was deemed constitutional because it was only used to promote greater diversity in the admissions for the college. Finally, is affirmative action right or wrong? Well, there is no right answer. Some people argue that yes, it is wrong because people who are born with a certain race cannot control whether they are advantaged or disadvantaged. On the other hand, some people are inherently at a disadvantage when it comes to getting equal footing with other competitive applicants. Thank you for listening. Hey guys.
Hey, Adam.
What's up? We're doing a unit on equality in history.
What are you learning about?
Well, we learned that there are several ways to interpret equal rights.
Cool.
Hi, Mom. Can I have breakfast? You want to write it?
Loving versus Virginia was a court case in which the court argued whether Virginia's
Anti-misogynistic?
No.
What does it mean? What, anti what?
Equal rights.
This is Alexander Hart at the scene where a couple of protesters have riled up at Capitol Hill. We're about to interview some of them now.
Equal rights.
Excuse me, ma'am. For what are you protesting?
The Equal Rights Amendment.
The Equals Rights Amendment.
Shut up, Mili!
Aidan is really just dropping it and giving it.
In fact, takes the entire hour to do.
Get it right, you two!
That was right!
I got it right. The first time,
literally-
the second time, the third time.
Yes, that's fine. Okay, yes, okay. Yes, you're right. Who needs work? Just go away. Oh, you're right.
My dog is always right.
What's your opinion on the Equals Rights Amendment?
They were known anti-rights.
Yeah, me too. Good point. Okay. It's yummy!
And it's made for me. It's peanut free.
Yeah, exactly. See, I was so everything else had almonds. Everything
it's
else had
yummy.
almonds.
Where does it say yummy?
Here it says gluten-free, vegan, peanut-free. Yummy. Like they just
Yummy free. It's yummy free.
yummy-free.
It looks unbaked. Like, look at it. It looks completely
Guys, should we put it, like, on a
unbaked.
plate when you give it to me? So guys, here's some behind the scenes.
I'm gonna work
what
here.
are you doing,
You guys,
Arista?
I'm editing the script right now.
And Ananya, what are you doing?
I'm attaching the tripod, or setting up the tripod.
And
working.
Aidan, what are you doing?
Working, unlike you.
Can you be more descriptive? You're using my iPad. Mili, what are you doing?
I'm cleaning
Okay.
up. Not like cleaning, but I'm like cleaning up, like so. Like,
Yeah, we get it.